Hello, everyone. This is Phonexa and Troutman Amin, long time coming webinar related to the FCC regulations. For those of you that know the Troutman Amin firm with Eric and Pooja, you know that they have been talking about this for a long time, and well, as long as it's come out, but very, very frequent and often. And it seems like there's still some lingering questions. And so the purpose of this platform and the webinar is really to go over what questions people are really asking, why they're asking the same questions consistently. I completely understand because everybody has an opinion on how to apply this to their industries, how to apply this to their stakeholders, and it's just not as clear and concise as we would like it to be. So we're trying to move one step closer to formalizing what needs to be done, how it needs to be done, and quite frankly, is it going to come out as it is or is it not, and what's the timeline and how much time people have to actually implement some changes. So with all of that said, I would love, Eric and Pooja, if you could do a really quick intro. I know most of the people in the industries know you, especially the ones that operate in lead gen spaces, but I think it might be a really good idea for you guys to just jump in and give us your background.
Yeah, no problem. So I'm Eric J. Troutman, the czar of the TCPA. I think I'm fairly well known to folks, but I run TCPAworld.com. I'm the president of REACH, which is Responsible Enterprises Against Consumer Harassment, the big trade organization for the lead gen industry. And of course, I'm a partner here at Troutman Amin, where I've spent the last 15 years of my life doing TCPA defense work, litigation, and also compliance, helping businesses to comply with the statute while also doing advocacy work to the FCC to try to keep those guys on the rails and doing intelligent regulation, which they mostly do, and not anything that's too crazy.
Hi guys, I'm Pooja J. Amin, also known as Queenie of TCPA World. I am now a partner at Troutman Amin, of course. Previously, I was in-house counsel at Loan Depot, where I spearheaded the compliance for TCPA and TCPA litigation. Thereafter, I was general counsel of a lead gen company, where I also assisted with compliance with TCPA and marketing and advertising.
Thank you, guys. So for those of you that don't know, I am Lilit Davtyan. I am the CEO of Phonexa. We are a performance marketing platform. And what sets us apart and unique in this very specific discussion is from a platform perspective, we are faced with the challenge of clients asking us what we're doing to implement tools and capabilities related to the FCC regulation. And then we also have a lot of networks that we also help operate that, are the clients, right? And so now we have the perspective of what do the lead gen companies need to do? What do the networks need to do? What do the advertisers need to do? And on top of that, taking all of those categories into consideration, what do the platforms need to do to accommodate all of those different types of stakeholders in the same industry? So with that said, let's go through the basics. What is this regulation? What does it mean? And is it only affecting the lead gen ecosystem?
Yeah, so at the highest level, the regulation is the TCPA, right? It's the Telephone Consumer Protection Act. It's the statute that really regulates outbound dialing in this country. Outbound dialing really for lead gen purposes is mostly focused on marketing. And so in the marketing world, you're going to have two different components of the TCPA that are going to apply to you. One is when you're using regulated technology. That's auto dialers, pre-recorded voice technology, artificial voice technology, AI technology, outbound IVR. Any of those kinds of dialing devices or outreach channels, you're going to have express written consent. And that is what we're going to be talking about today, is a modification to that definition. You also have the second piece, though, which is the DNC list. And anytime you're doing an outreach without consent or without an EBR, an established business relationship, the TCPA's DNC rules are also going to apply to you. There's a different definition of express consent there. It's prior express invitation or permission is the standard under the DNC. That rule has not been changed, most likely. A little bit of wrinkle there, but that's, I think, a little bit outside what we're going to talk about today. Primarily, we're going to be focused on express written consent. So if you're using any form of regulated technology There is a modification that the FCC has just done. And the big modification here, just put it in a sentence, today, previously, before the new rule, you could sell essentially a consumer's consent to multiple entities that were described or identified on a form. After the new FCC ruling goes into effect in January of next year, you can no longer do that. The consumer has to select on a one-to-one basis who they want to hear from. And they have to be providing that express written consent to one seller, only one seller at a time. And the seller is not the caller. It's not the lead generator. It's not the lead seller, because that's how we think about seller in this space, right? We think about lead seller. No. It's not the lead seller. Ironically, it is the ultimate lead buyer, right? The good or service provider who is going to be helping that consumer with insurance or with the mortgage or whatever it is. Whoever's providing that good or service, they are the seller. That is who the consumer has to, on a one-to-one basis, sign up to hear from.
Perfect.
Yeah, and Eric, just to kind of piggyback on what you were saying, like just to reorient folks, before this ruling came out, right, you had to think about what the lead gen industry was doing. Previously, currently until 2025 now, the lead gen industry would have a list of tons of marketing partners listed on their website. Might be a website about mortgage lending, for instance, but then you try to sell them solar leads or, roofing leads. And so a lot of leads have been being generated off these websites and sold to multiple entities over and over again. You could sell leads up to 100 times if you wanted. There's no rule saying that you couldn't. And so the FCC really got frustrated with this kind of lead gen industry selling leads back and forth without having very specific consent to the product and the service that they were actually trying to sell. There were no standards, and the FCC essentially got fed up with it. And this is how we came about this ruling.
Thank you for that. And before we get into some very specific questions related to the new ruling, again, general, what does this mean in terms of, do we think this is going to launch exactly as it's written as of today? And two, what are the consequences for businesses that are delayed or not following the rule?
Pooja, you take the consequences. Let me take the first piece, if I can. Because it's actually a really interesting question, and there's a lot of pieces to it. Let me start with, is it going to go into effect in January? Because for some reason, people seem to just be reluctant. And I think it's a little bit of like ostrich head in sand syndrome that we've got in the industry right now. And this is not a surprise, because I've been talking about this for 2 years, right? Before the NPRM even came out, I knew this was coming. I tried to warn people. And it's like, no, it's not happening. This is all baloney. And then even when it came out, I tried to warn people. And I said, oh, come on, Troutman, you're making a big deal out of nothing. And now here it is in black and white. And people are still saying, come on, it's not going to really happen. It's unbelievable, right? The amount of reluctance and inertia that we see in this industry in some corners. Many, many folks, the good compliant actors, they understand this and they're moving toward compliance. But the question of, is this going to go into effect in January? The answer is almost certainly yes. Almost certainly yes. There is a tiny percentage chance, I would say, that the challenge by the Insurance Marketing Coalition down in the 11th Circuit Court of Appeals is somehow successful. I've taken a look at the briefing. I just don't think it's very likely. Now, look, it could happen, right? So I can't say 100% that it won't be set aside by the court, but I just don't think it's very likely. I think the FCC has enough of a record built that they'll be able to move forward with this new one-to-one rule. I know some people seem to think, well, hey, if Trump wins, he won't let this happen. And I just think to myself, you have just no understanding of how the government works. Even if Trump wins, there's absolutely no way the FCC is going to walk this back, certainly not by January 25th, and in all likelihood, it never will. So if you're thinking, hey, Biden loses, this is going to go away, totally incorrect. That's not the way this happens at all. Even if the administration changes, this is automatically in effect. It's not like the commission has to do something else. It's already done what it needs to do. So even if the administration changes, it's not going away. The legal challenge, there is one, it exists. It's not very likely to succeed, in my view. So put those two things aside. Okay, it's going to go into effect almost certainly in January. The question is, as you framed it, is it going to go into effect as written? Now, that's an interesting question because there was a second what's called an NPRM, Notice of Proposed Rulemaking, comment period that was reopened following some of REACH's efforts, right? That's Responsible Enterprises Against Consumer Harassment. The lead gen industry for the lead gen industry's trade organization went to bat with the Small Business Association at the FCC and did obtain some more time for small businesses, which almost all lead generators are, to weigh in on the impact of this one-to-one rule and to propose some modifications to the rule as it is written. Now understand, the core of the one-to-one rule is not going away. There is going to be a one-to-one rule almost certainly effective in January of next year. There is, I think, a fair question of what exactly it's going to look like around the words that are specifically used and the impact of those words. And of course, those are very important. So these are not suggesting that the modifications that are going to be made are going to be small modifications. They may still actually be very important, but the core of one-to-one is still going to be there. But for instance, something that might change, as currently written, as I mentioned, is you have to have the sellers, the consumer has to be authorizing the seller, right? Mentioning that seller by name on the form. It is conceivable that rather than the ultimate good or service provider, the seller, perhaps that word gets changed to entity, and then the consumer could agree to receive a phone call from an intermediary lead generator, right, who would then get the consumer on the phone and then offer different things. That is possible, but that's not how the rule is written today. So we're going to have to wait and see. I know nobody wants to hear that, what the exact language is going to be, and I'm predicting you'll see that in September or October of this year. So with that background, Pooja, what are the consequences for folks that are just not jumping on this?
Yeah, so for folks, as Erica said, the TCPA prohibits telemarketing when you're using regulated technology, which includes auto dial calls, pre-recorded, and of course, artificial intelligence. Now, if you're a company that is collecting TCPA consent using that regulated technology to market and market your products or services, you have to pay really particular attention to the new one-to-one rules, because previously you could be sued for ATDS violations, DNC violations, but now plaintiffs' attorneys have a different avenue in which they can sue you, which is if you have not obtained the one-to-one consent per the FCC new rules, whatever those rules end up being in 2025, you are now liable for $500 for a call or text up to $1,500. And this includes, as we know, for most of us know, class actions is very prominent in the TCPA world. So this new ruling essentially gave the plaintiff's attorney a new avenue to file lawsuits. Previously, as I mentioned, they only had avenues such as violations of the DNC rules, violations of the ATDS rules, and violation of prior express written consent rules, but those prior express written consent rules weren't as rigorous as they are now.
Yeah, and that's a really good point. So I'll add a question to what you're saying, Pooja, because one of the things Eric mentioned is obviously the person that's about to call, the company that's going to call needs to have the consent in order to call. All of that is understandable, but when we're talking about the lead gen ecosystem and the consumer journey, it could go anywhere from here's a publisher website, the consumer applies, goes through 2, 3, 4 networks before it even hits the caller. And so the responsibility of getting consent falls on the publisher, even though the seller is the one that's going to dial. And so now we're looking at when these attorneys do go and sue, what are we looking at in terms of who can they sue and at what capacity can they sue? Because one person called without consent, but was giving the requirement to collect consent to somebody else, and there's 3 different companies in the middle of that.
That is a great question, great point, Lilit. So, for the publishers that are developing these new consent rules and selling the consent to the ultimate sellers, what I see is that the sellers are going to become extremely strict with their contract terms, and they're going to come after the publishers if they're not providing the compliance consent records now. They're going to use contract terms and indemnity language to then go after and seek the costs and the attorney's fees that they are facing with the new TCPA litigation. And then to your question earlier, TCPA plaintiffs' attorneys are typically suing the folks that are making that call or the text message on behalf of that ultimate seller. Now, I can see, if you're doing warrant transfers, for instance, there's oftentimes the warrant transfer partners will be included into the TCPA litigation, but typically it is the end seller, the brand, right, that is selling their products or services are the ones that are facing most of the risk here. But Now I can see a world where the brands are going to have to become extremely strict on what partners they're choosing and really holding their partners responsible if they're getting faulty consent records.
Good point. So from the ecosystem perspective, let's take the platforms now. So we talked about the publishers, the networks, the advertisers that are dialing, but the platform that's giving these tools, take Phonexa as an example, right? Obviously the tools are there, and we are relying on our clients to tell us we have auto dialing clients or we don't. What happens when that's not necessarily the case, right? A lead flows through based on the tools they've decided to use. An auto dialer happens without a consent because it was supposed to be manual. Do the platforms fall in this ecosystem of non-compliance?
Great question. The platform liability, courts are split on how platforms can be liable, but there's nothing in the TCPA that's going to prevent you from being sued. It's going to depend on how involved were you as a platform in doing the illegal violation, right? The illegal act of calling someone without the appropriate consent levels. But platforms are not immune from TCPA liability. And in fact, platforms do often get sued. Now, there are legal defenses that you can kind of play once you're into the lawsuit, but for preventive measures, right, as a platform, you don't even want to get involved in that suit to begin with. So typically, there's ways you can develop your relationships with your vendors as a platform to make sure that you have some controls over compliance, but not too much where you're not dictating the actual marketing that's going on, and whether you have too much control over the illegal act is something that the courts are going to look at.
And that last point, Pooja, you nailed it. I mean, it's fascinating because when you look at our firm, Troutman Amin, you look at our client portfolio, we have a really large number of platforms that are our clients, which is fascinating because as you just laid out, platforms are not in the direct line of fire. They are not the caller. They're generally speaking not the initiator of the caller. They're not the brand. The calls aren't on behalf of them. They're just, generally speaking, the pipes that are being used to make these calls. And yet, I think wisely, the sophistication of the platforms is, well, wait a second, the scale at which violations might be taking place on any platform really requires you to really think it through what you're doing and how you're doing it to make sure that you're not putting yourself in harm's way along with the people who are actually using the platform. But Pooja nailed it. I mean, that's exactly the kind of criteria. And I did just want to mention, though, Lilit, you are so obviously knowledgeable in this world, and publishers and the intermediary networks, and they're going on the platforms and they're going to the sellers and the brands and the intermediaries and the call centers, maybe even VPO, and they've got all these different people, right, that might be touching a consumer's data. The FCC doesn't understand that, and generally speaking, the courts don't understand that, and so the rules that they keep framing out are many times, they're like binary. It's like, well, either the website operator or the brand has the data and is getting consent. It's like, wow, you guys just don't understand this at all. So it's important for everyone to understand, and this is why I think there's a lot of difficulty ingesting in the industry these rules, is the rules are orange and the world we live in is red, right? It's like they don't fit. One of these things is not like the other. And so I think there's just a lot of cognitive dissonance. Well, this rule doesn't look anything like the way the world actually works, so we're not going to try to apply it to the way the world actually works. But you're going to have to. All right, and that's the trick. That's the challenge. And many of the things that we see in the world right now are going to have to start to be modified in order to conform with the new rules.
Totally. And on the topic of the regulators not understanding, because of that, obviously people are applying this to their business when in some ways it also doesn't apply to every part of their business, right? So one example is a lot of lead generators are not just sellers of leads that get calls. So it doesn't affect their ability to submit forms and ping and sell that lead. It's a matter of, if you know that your buyer is going to dial, you need to take these additional precautions. The other concerns that I've been hearing very, very often is, well, what if the buyers don't want their names, or what if the networks don't want to share the names of their buyers to the publisher that is responsible to get consent? My response to that, you're going to kind of have to get over it. At the end of the day, this is changing everybody at the same time. So one company can't decide this versus the other, because then the publisher wouldn't even know what to showcase anymore, So that's becoming a challenging question that we're trying to explain like it's going to look like a new world, and we just have to jump on that ship and we have to make the change, and we all have to kind of be like, hey, we all work together anyway. But have you seen any solutions or any feedback that companies have given on how to keep the relationships confidential in collecting this consent?
Well, no, I'm with you, Lilith. The answer is tough luck, right?
Mm-hmm.
Tough luck. And that's just the way it is. Now, even before the new FCC rule came out, right, Reach, of course, was advocating for transparency with lead buyers requiring that networks identify publishers so that the URLs could be reviewed. So we were already heavily in favor of transparency in terms of publishers being shared with buyers. But now, to your point, the new one-to-one rule essentially mandates that there's transparency the other direction, which is that the networks have to share the names of the likely buyers with the publishers. There's just no way around it, right? There's no way that publisher is going to be able to correctly obtain the one-to-one consent that is required by the consumer selecting the brand, the seller, without the publisher knowing. Now, the other option is the publisher could just put random names in there and hope that the networks they're selling to have the relationships and just fire away. And I guess some network might buy it and some network might not buy it. And maybe they can kind of glean, they've got a relationship. But, obviously there's loops and there could be a relationship with a relationship with a relationship. So I guess, a publisher might just throw Wells Fargo in a form and hope somebody they work with has a relationship with the Wells Fargo. Right? I mean, that's not possible. That's what they do. But I think if you're an intelligent publisher, if you're an intelligent network, you've got to understand that there's got to be transparency. There just has to be.
Yeah, and you got to keep the consumer in mind in this process, right? What you don't want to do is throw in 200 random names, overwhelm the consumer. Most likely you get no consent on any of it. Nobody is going to want to get a big chunk of calls in the next, 3 minutes, followed by months and months of calls, right? So that's also something that we need to consider. It's not just about the businesses. What does the consumer journey look like? How does that change? Obviously, the consumers are getting a lot more transparency in the process, and they applied for something, so they're going to consent to something or someone. So I don't think that the idea of we're never going to get consent is realistic if the consumer initiated the entire process of applying for any product or service. I have a question for you. So I'm going to read part of the ruling. I think it's coming from the ruling because it's becoming a question now with a lot of people. So it says, calls and texts must be logically and topically associated with the website interaction that promoted the consent. What does logically and topically mean?
Pooja, you can do that one.
Short answer, no one knows, but we do have, insights into the FCC ruling on what we can reasonably expect that to mean, right? So the FCC has actually declined to adopt a definition of logically and topically related, unfortunately. So all they're saying is that texters and callers should limit content to what the consumers would clearly expect, right? So going back to your point, Lilith, of putting yourself in the consumer's shoes, essentially, right? If I am looking for a mortgage and I'm on a lendingtree.com, for instance, and I'm filling out information that is required to get me a mortgage quote, and then I get called for pet insurance, right? You put yourself in a reasonable consumer's shoes, I'm pretty sure the FCC is not going to look at that and think that it is something that a consumer would reasonably expect. Now, I think those are kind of like the obvious examples, right? But it gets a little bit more tricky, for instance, if you're looking for a mortgage, but then they want to sell you homeowners insurance, right? Is that logically and topically related to a mortgage? Now, to me, right, if I'm on a website, it depends, right? Is the website catered and developed in such a way where I'm on the website and I have different options of things that I may be interested in alongside getting a mortgage? And if I am going down, for instance, different funnels or different questions where I am affirmatively answering in the yes of wanting additional products and services, then perhaps, right? So publishers especially are going to have to become extremely creative and really think about consumers now instead of just slopping together websites and just kind of putting every type of service that they think that they want to robocall the consumer about, and that no longer can be the case, right? People are going to have to get creative. They're going to become creatively compliant now when they're developing these websites, because now this is now going to be another avenue that plaintiffs' attorneys are going to be able to sue under the TCPA, right? Previously, this wasn't something that the plaintiff's attorneys were bringing lawsuits for. And now, really, if a consent isn't logically and publicly related, it's going to be determined by the courts. And it'll be really interesting to see how conservative courts become, or how lenient they are looking at the website.
Yeah, I would say, and Pooja, you got a really good point in terms of how you can have different calls to action to broaden out your website to allow you to obtain truly logically and topically related consent about products maybe in multiple verticals, if it's clear to the consumer that you're not just offering mortgages, you're offering assistance with moving into a house and everything you might need, including a real estate agent and a mortgage and pet insurance and solar, right? You can structure your offering to that consumer so that it's clear to the consumer that you're going to be getting offers across multiple verticals. But in the standard scenario where you come into a website because you want to know about mortgages, right, in today's world, or you go onto, realtor.com or some real estate website, and they try to cross market, right, and obtain a consent that has to do with something that might be related, right, to the mortgage or to obtaining a real estate, like for instance, obtaining a mortgage or obtaining an agent, but it's not the exact same thing the consumer is actually looking for, right? Where's that line of logically and topically related? To me, to my eye, again, nobody knows for sure, but to my eye, if the offer is X and you depart from X, right, you're instantly in harm's way. And I'm talking, if that says, apply now for a 7% 30-year fixed, and they call in and they can't qualify for a 7% fixed, right? And you call them and you offer them a 10% fixed or a 5% ARM or a different product, even that might not be logically and topically related to the exact transaction that consumer came to you for, right? So if you think about even being within the same vertical, the same product, just a different offer might be outside of logically and topically related. Imagine now how much more difficult your life is going to be if you're going to try to sell that mortgage customer a HELOC, a cash out, or a personal, or solar, or pet, and you just keep going further and further and further away. And true, some courts might say, hey, look, the same offer, different offer, HELOC, it's all financial services, whatever. But I'll tell you, there's going to be some courts that look at this and say, they came in for a 6% fixed, you offer them anything else that's not logically and topically related, period.
Yeah.
One additional point. The only information that the FCC ruling actually gave us that we, as attorneys and compliance folks that are hanging on to, when I look at it, the FCC specifically said to illustrate the intent behind the rule, they gave the example of a consumer giving consent on a car loan comparison website that does not give consent for robo-text or robo-calls about loan consolidation, right? So they use two very distinct products and services in their example, but that's not to say that the courts are going to interpret that or look at that as the only example of something that is not logically and topically related.
Got it. Makes total sense. And I know we're going to continue to define these terms and specify to what it means for specific companies as well. But what we did is we actually did ask people in our ecosystem, companies, our partners and clients, specifically what is so confusing to them. One of the most common questions is this, not so much a question, their strategy to this. Look at it from a network perspective, right? So the network is not offering a name, a brand, they're offering a service that's going through publisher websites, whatever it is. So they're saying it's easier for me to use my call center or create a call center to get one consent, which is my company's consent, have my company call center agents call the consumer, I have consent, and then get consent to either transfer that call to other buyers or get consent to have other buyers call the consumer later. What do we think about this?
Can't be done, right? And that's the entire issue with seller as the requirement. Many folks think one-to-one just means one entity calling. Wrong, false, incorrect, not true. This is the number one, I think, falsehood, misinformation that's floating around out there in the industry. Now, that might change, and if it does change, great. That's one possible potential solution, right? There's hair even on that. We can talk about it. But structurally, from a process standpoint today, right now, the ruling as written does not allow that. because no, you as a call center cannot just spin something up, put your company's name on there and start calling. The consumer has to have Allstate, Geico, right? The actual ultimate insurer is the one whose name is on the form, not Bob's Insurance Broker Inc. That's not the way this is going to be structured. Unless, right, the call to action on the website is to have the consumer not obtain a quote, not obtain an insurance product, but obtain assistance from a broker in trying to find an insurance product, in which case, of course, you have to have licenses, you have to put the consumer's best interest first, right? There's the whole thing that comes with being a broker, which many of these companies that want to spin up the call center to make these outbound calls, to make these offers, they're not going to qualify, right? So this is not a path that's available to most lead generators. It's just not a viable path, at least as it's currently structured.
Yeah, unless you want to put yourself in that broker situation and make it very clear to the consumer that is your business, that's what they're consenting to.
Correct.
Understood.
In which case, absolutely, then you could, right? But you have to take that next step and actually become that broker.
Yeah, and I have a very related question that specifically came from a partner of ours. So the question is, if we generate leads for a life insurance agency, example, one-to-one consent is for Smith Insurance Agency, can independent agents who are contracted or affiliated by Smith Insurance Agency be the ones to contact the prospect?
Yes, that's the good news, right? This one-to-one rule, it kind of cuts both ways in a weird way. It makes it very difficult for you as an intermediary who's not attached to any particular brand to get you on the phone and try to pitch you a brand. That's not allowed. But the good news is that if you're a major brand with a huge network, even of independents that are out there authorized to sell your stuff, if your name is on the form as the big brand, then anybody, even independents, can call that consumer and offer you that brand. Now, the limitation is that independent agent couldn't say, oh, you don't want Geico? Well, then let me sell you Progressive instead. No. That consent was only for one brand. And if it was Geico, they can only sell Geico. If it was Progressive, they can only sell Progressive. But everybody in Progressive's massive networks, whether they're captives or they're independents, can make that call. And It doesn't have to say, Bob's Independent Insurance Agency, LLC. It just needs to say Progressive. That's it.
Yeah, I'm going to go a little bit off topic. It's still FCC related. But, let's talk about AI. Again, questions that come up a lot, right? Is the FCC going to come out with regulations related to AI and how it's being used in the lead gen world too? A lot of chatbots are now created through AI, and we won't get into, hey, AI is not licensed to sell insurance, but what is what is the FCC thinking, if you know, about upcoming AI, because it's coming so fast and they're still trying to get into this consent one-to-one consent pass through, but AI is a lot faster than we expected.
So in February, go ahead, Eric.
No, go ahead.
In February of this year, the FCC did restate. The reason I say restate, because for us TCPA lawyers, it was almost obvious and a no-brainer that artificial intelligence would be covered and regulated by the TCPA, hence the word artificial in the statute itself. But the FCC did confirm earlier this year that use of artificial intelligence is going to be subject to the TCPA and be considered regulated technology, meaning that in order to use AI technology, you're going to have the prior express written consent, just like you would if you're making calls or texts with an ATDS or pre-recorded calls. So now within that bucket of regulated technology, you have artificial intelligence as well.
Yeah, and there really are kind of like three different components of the AI regulation that everyone should keep in mind. First is like the good boy AI that like Pooja's talking about. Like, this is good AI that's being used. It helps the consumer. It's marketing. It's like, hey, how are you? Gives you a nice experience. It says the right words. It's compliant. It's good. It's good for the consumer. That is regulated technology, right? You have to have prior express written consent under the TCPA, including under the new one-to-one rules, in order to deploy that technology. So even though it's good technology, it's consumer friendly, it's still treated essentially as a robocall, even though it's very dynamic and ultimately will be even better than a human agent, right? And talking with the consumer, still, that's a robocall. There's other kinds of AI, though, as we know, like bad boy AI, deep fakes, and things like that This has always been regulated, not just under the TCPA, but under other federal law, and the FCC is the primary regulator. And we just saw those knuckleheads in New Hampshire who did a deep fake on Biden got hammered for $6 million. And by the way, the platform that enabled it, Lingo, got hit for $2 million just for being the platform that was used in order to do these. And as far as I know, Lingo itself did not have anything to do with this specific bad boy behavior, and yet they got hammered, right? So those of you that are platforms that are offering AI technology, keep this in mind. If it is used for deep fakes, you are going to get hammered for that, all right? So you've got to be very thoughtful and only make sure you're using it for good purposes, in which case, of course, it still has to have consent. And then the last piece of AI regulation that's running around, and by the way, the FCC and TCPA world, this is the primary regulator in the country right now of AI. Like, you've come to the right place. It is TCPA world. It is TCPA. It is the FCC. They are the regulator. The other piece is whether or not you have to disclose the use of AI. And the chairwoman, Rosenworcel, just put out a statement last month saying, we think you have to disclose it. Now, that ruling has not been made yet. That's not final. That's just like one commissioner talking. But I would anticipate by the end of this year that there's going to have to be a disclosure anytime you're using AI at the outset. Hi, this is your AI virtual friend that's here to talk to you, as opposed to what we do now, which is, hey, this is Bob from wherever. So keep that in mind.
Yeah, and Eric, I'm 99% sure that the FCC will come down with something, because one thing that I'm doing here at Troutman Amin, Lilith, is tracking the state laws with AI as well. And the new state bills that have been passed, there's at least a dozen of them currently, and they are addressing the definitions of deepfakes. They're addressing the definitions of using AI when it means it's deceptive. And I'll note that the majority of these states, forget civil penalties, they are considering it a misdemeanor up with jail time. So, state laws are, in addition to the civil penalties that you may face, you can also be facing jail time for not properly disclosing the use of AIs. And additionally, a lot of the state laws are requiring a specific disclosure. So they are telling you verbatim the language you have to stick in on the call or the advertising that where you're using the AI.
Got it. This is a perfect segue, actually. So obviously, companies need a centralized place to go to and find out all this information. It's hard to watch webinar after webinar to get all of the information and all the questions answered. So let's talk about Reach. Let's talk about why Reach started, what it does today, and which we're a very proud member of, and what is the future of Reach. So that way our audience can understand. And there is that centralized place now for information. And I would love for them to know the steps to have access to something like this.
Well, I love it, Lilith. So Responsible Enterprises Against Consumer Harassment, REACH, is the trade organization for the lead gen industry. It actually was created to address the problem that Pooja identified right out of the gate in this webinar that led to the FCC, frankly, overstepping in its regulations, which was the lack of standards, right? The lack of clarity in the industry, the fact that a consumer could go to one website and end up having their information sold dozens of times over a period of months, if not years, right? With no standards in terms of, is this acceptable in the industry? Is it not acceptable in the industry? How big does the font have to be? What words have to be used? Where does it have to be seen, right? How tricky can you get in removing friction from the funnel as part of the lead gen process? None of these questions had answers until Reach came along. And Reach has been around now for a few years. We put out a first set of standards right before the FCC entered its ruling, and that first set of standards, of course, everybody who's a Reach member, both a lead buyer and a lead seller, agree to abide by these standards, which is very important in terms of kind of cleaning up the industry. But now, as we wait for the finalized FCC ruling, Reach Standards 2.0 will be coming out probably in July. That will try to build in best practices around the one-to-one rule, in addition to, of course, the other kinds of rules that you're going to want to see for both lead buyers and lead sellers. All of this is done to put everybody in the market on the same competitive footing, so that people aren't cheating. There's not a race to the bottom anymore. And most importantly, that lead buyers are going to stop buying bad, cheap, terrible, fraudulent leads, which is, that word fraud we didn't even use yet in this webinar. To me, that is a very substantial driver of the TCPA lawsuits that we see. A substantial driver of the government regulation that's coming down is the concern that consumers aren't even going onto these websites. And yet many of these websites are just generating these leads falsely and fraudulently, selling them into the marketplace where there's no way to track them. and they end up in the hands of, frankly, innocent lead buyers who are making outbound calls and they end up getting sued in TCPA. It's really bad stuff. But Reach is here to stop all of that, to put standards into place, to create a positive, holistic ecosystem of good players, good actors who want to be compliant with the law, to liaise with the regulators directly, to have a say in the outcome of regulatory activities, such as the creation of the one-to-one rule, to lobby for the good actors in this industry and the superpower for the American economy, which it really is. The lead generation industry is a fantastic industry. It helps small business. It really does when it's done right. It's like the greatest thing. It really is. Now that I'm a small business owner, I see how important it is. But when it's done wrong, it's also a massive contributor to the unwanted robocall epidemic in this country, right? So we have to take responsibility as businesses in this industry to make sure it's done right, to help small businesses, to give consumers what they need, while also preventing these unwanted calls that it's just not good for anybody. It's a terrible thing. So that's Reach. That's the mission of Reach. And if you want to join, of course, you can visit Reach MBC. That's Mutual Benefit Corporation, reachmbc.com, or you can reach out to me or to Pooja. Or to Lilit, our newest board.
We'll be sure to provide some information with this webinar for people to know where to access it as well. I wanted to thank you guys so much. You know, aside from this webinar, you've always been available. And when you're not able to have one-on-one calls with clients, you're able to publish so everybody can benefit from the information that you're directly gathering related to this regulation. And I know future regulations, and hopefully with Reach, you can also prevent other regulations from coming up that are going to, once again, change the entire ecosystem. So thank you so much, everybody, for watching. Thank you, Pooja and Eric, for participating in this webinar. We'll provide our audience with the ability to also ask additional questions, which we can send back responses to as well. So again, thank you for watching, and I look forward to figuring this out sooner than later.
Thanks, all.
Absolutely. Thank you, Appreciate you. Bye.